Medico-legal aspects of medical practice. So nowadays there is an increase in medico-legal cases. Uh, Recent developments have shown that medical field has revolutionized the field of medical practice. So patients are expecting more and more from the doctors, which is increasing the dissatisfaction among the consumers and leading to much more incidents of litigations, etc. So when it comes to the practice of medicine, does not evolve only about its curative aspect, but it is also concerned with the medical legal aspect relating to the doctor-patient relationship, doctor-doctor relationship, doctor and the state of law relationship. These are the various areas of a medical legal issues in healthcare. So some medical legal issues are a quack. A quack is a person who doesn't have knowledge of a particular system of medicine but practices that system. Is a quack. Where a person is guilty of negligence per se, no further proof is needed. For example, an Ayurvedic doctor, homeopathic doctor, or a naturopath is practicing the allopathic system of medicine. So you term them as a quack. Informed consent. There exists a duty to explain prior to any diagnosis, treatment, organ transplant, or research purposes, disclosure of medical records. Okay, before doing any of these activities, prior consent has to be taken with respect to living patients. If the patients are, if the person is dead, their family, the near next to kin, is responsible to give the consent. Coverage of doctors and hospitals under CPA. As long as the medical professional or hospital have paid patients, okay, all the patients are consumers, even if the treatment is given free of charge. Even if you have inpatients, you are not charging much, but there are inpatients who are paying the hospital. Next level, you have patients below poverty line, you are giving free services to them, but still they are considered consumers, because even if you have a single paid patient in your hospital, the services you give to all the other patients come under Consumer Service Act. Claim for damages. Claim for damages based on the principle that if a person has committed civil wrong, he must pay compensation by the way of damages to the person wronged. So that is the claim for damages. If it is proven that you are wrong, you are obliged to pay a compensation to the person whom harm has been caused. So some other important points is about death of a patient. So a patient while undergoing treatment dies, okay, doesn't necessarily mean medical negligence. Okay, next is error of judgment or failure to cure. If the doctor was not able to cure the treatment, cure the disease or the problem, doesn't necessarily mean that he is liable for medical negligence. Then engaging with specialists, when specialists are available, engaging with specialists is obligatory. Critical conditions. When a patient could not be operated due to the critical condition, he's already in a critical condition, because of which operating and further putting them into anesthesia may cause more harm than good. So this will also not come under medical negligence. Then incomplete medical history. If the patient is not providing a correct medical history, is not giving proper full medical history to the doctor, okay, the doctor cannot be blamed for the consequences. And liability of the hospital. Any wrong claiming which is done on the part of the consultants, the hospital has to take the liability of it. Some exceptions for informed consent. It may be not necessary in the following situation. The first is emergency situation. When there is an emergency, you have to take decision without waiting for the consent to save the life of the patient. While working in situations like public interest, like during floods, cyclones, earthquakes, during disaster management, whatever decision you take, consent is not required. Treating patients in places like mental asylums or orphanages, consent is not required. Working under court order, example, in case of smuggling operations are done for directing narcotics or gold kept inside the intestine or the body, some drugs are kept into the rectal area, etc., to smuggle. Okay, in such cases, consent is not required. The doctors can do their work from under the court order. Next is a few laws that are relevant to doctors and nurses. Criminal law is applicable to all individuals, and doctors are not any exception to it. So, in the last few decades, the doctor patient relationship has deteriorated, and complaints against the doctors have increased. Even if the doctor is performing under good faith, okay, still they become the victim of medical negligence. So, awareness program are conducted. Awareness of criminal law, such seminars and conferences are conducted to make the people be aware of the medical negligence cases. Section 304 and 304A, death due to medical negligence. So there is a little discrepancy in applying this law because what section 304 says is it was purposeful. The doctor purposefully harmed the patient, which may lead to some mental agony, hardship, or some professional stigma. Okay, in 304A, what happens is the doctor didn't perform any act just because of any malaise. Okay, it was done with good intention, with good faith, but it turned into negligence. So, in fact, that is the basic difference between section 304 and section 304A. Intent is the main difference here. Section 319 to 332. These sections are related to causing grievous hurts such as loss of limb, loss of vision, hearing, loss of hearing, disfigurement, etc. Whereas section 336 to 338 deals with causing grievous hurt purposefully and other negligent act. Examples are leakage of IV fluids into the surrounding tissues and causing subsequent necrosis of the limb, etc. Surgical processes without adequate aseptic precautions, purposefully doing all these things. Okay, an unqualified doctor performing a surgical procedure which results in permanent damage to eyes, limbs, hearing, any motor or neurological function. Okay, that comes under section 319 to 332 of grievous hurt. Then section 340 to 342, wrongful confinement. Patient cannot be detained on the grounds of non-payment of hospital charges. So you can't detain a patient just because they have not paid the hospital charges. This may constitute as an offense of wrongful confinement under the section 340 to 342. Doctors can take advantage of advance fee from the patient before starting the treatment. But after treatment, if the patient is not able to pay the fee, you can't tie them up to the bed or confine them without their will. If the police officer is keeping a doctor in detention, in cases of bailable offenses, the police officer is liable for offense of wrongful confinement. Even if the police is arresting the doctor, even in where the doctor could be bailed out, even after that, the police officer is keeping the doctor in detention. Now the police officer will be the guilty person here for wrongful confinement. Section 90, consent in criminal law. So a valid consent must be given voluntarily by an adult who is in sound mental state. The consent must be given after reasonable understanding and without any misrepresentation or hiding the facts. Thus, the consent should be an informed consent, preferably in writing and in presence of a witness. So these are the things that you should keep in mind while taking consent. It should preferably more than oral consent, written consent is preferred, and it's better to have a consent taken in presence of a witness. And when the adult is not in a sound mental state, the next of kin is responsible for giving the consent. In cases of organ transplantation, the doctor may have given consent under family, social, or financial pressures. In such cases, proper counseling should be given to the donor in presence of witnesses. And in case of dead donors, there is no expressed will. The body is the property of the heirs of the dead donor, and their consent is enough to continue with any organ donation plans. Criminal liability for wrongful act. The law imposes liability on him who fails to perform the duty. So that's the wrongful criminal liability act, the statement. Wrongful act may be intentional or willful wrong, but this does not apply in medical practice because no doctor has the intention to harm his to cause harm to his patient. So Criminal liability for wrongful act usually will not apply in medical practice. Other relevant laws are the Negligent Act. If the doctor fails to take proper care precaution and is just indifferent to the consequences of its act, so that's a Negligent Act. Under that, the doctor is guilty. Wrongs of special status. Some strict liability created by some special statutes like Transplantation of Human Organ Act, Medical Termination of Pregnancy Act, for example. Okay, special statutes are created for this particular procedures, medical procedures. So according to that, you have to follow the law of the land. Summons is the process of court asking the defendant to appear and answer the allegation preferred by the party who has brought the action. So summons is like the court orders you to appear in court because there is an allegation on you by a plaintiff. So in that case, if you are summoned, if you get the summon letter, you are obliged to attend the court on that particular day, that particular time, to defend yourself against any allegations. Warrant. Warrant means an order issued by the court magistrate or a competent judicial authority directing the police officer to make an arrest, seize or search or perform any other judicial duties incidental to the administration of justice. So if there is a warrant issued, a warrant letter issued by court, magistrate or any judicial authority for any arrest, it has to be followed. The police should not be stopped to take the orders from the court. A warrant case is related to an offense punishable by death, imprisonment or imprisonment far more than 2 years. For example, if a doctor helps a pregnant woman in unauthorized and unlawful medical termination of pregnancy or to cause death of her child after its birth. Okay, in these cases, this becomes a warrant cases. So arrest can be done with a warrant letter. Cases other than warrant cases are summons cases. For example, if a doctor acts negligently by using an infected syringe or by using improperly sterilized instrument, resulting in an infection to an uninfected patient. Okay, these are a summons case where you have to plead guilty, or you may have to appear in front of the court and play your role as a defendant. So that's a summons case. Cognizable offenses. Cognizable offenses are those in which a police officer may arrest without warrant, according to the Schedule 1 of Criminal Procedure Conduct. So non-cognizable in warrant is not required in cognizable offenses, but in non-cognizable offenses, a warrant is required. For example, a doctor knowingly disobeying the quarantine rule, okay, should be punished, is liable for imprisonment, etc. So in non-cognizable offenses, warrant should be there to confirm the arrest. In cognizable offenses, without a warrant, police officer may arrest. Ignorantia juris non excusat. Mistake of law means being unaware of the existence or mistaken understanding of the law, including erroneous conclusion of the law, is not excusable. For example, if a doctor from outside India, where prenatal sex is done legally, but was not knowing that in India prenatal determination of sex is illegal, it discloses the sex of the child to the patients or to the client. So that becomes a mistake of law that is not bailable, and the doctor cannot be excused. The mistake of fact is another thing. Is a situation where a person commits something wrong due to improper facts or incomplete facts, but the intent was never intended to be guilty. The intent was in good faith, but was misrepresented with some facts. Okay, in such case, person may not be held responsible. Res judicata. In res judicata, this doctrine means that doctrine of law means that things have been decided. According to this, for example, if a patient has complained against the nurse for any nursing malpractice. Okay, the organization takes action against that. Again, next time when the patient is admitted, and again when the patient wants to make the same complaint for the uh, for on the nurse for her previous action, it is not entertained, because things have been decided, actions have been taken. Now you can't keep on repeatedly asking the court to, or the organization to, take action for the same mistake committed in the past. Okay, so that is, things have been decided. Res ispa loquitur. In res ispa loquitur is a situation of gross negligence or rational. The things are so obvious that they speak for themselves. We don't require any proof to say that something gravely wrong was conducted. Most of the time, there is no need of the proof or documentation of negligence in such cases. Common examples include giving blood transfusion to the wrong patient, operating on the wrong side of the body or wrong patient. Okay, these are the examples of res espa loquitur. The actions speak for themselves.